arbitration agreement, 仲裁协议. An arbitration agreement is a written contract in which two or more parties agree to settle a dispute outside of court. The arbitration agreement is ordinarily a clause in a larger contract. It is a prerequisite to arbitrate a dispute. There are two forms of arbitration agreement. The arbitration agreement can be stipulated before a dispute arises in the sales contract as a clause, or after a dispute arises. The arbitration agreement can be submitted to the arbitration institute. Those two kinds of arbitration agreements have equal legal effect. The function of the arbitration agreement is that it eliminates the rights to bring a suit to the court of law. An arbitration agreement in a sales contract should include the following elements. 1. Place of arbitration. It could be in the plaintiff's country, 申请人的国家, or in the defendant's country, 被申请人的国家, or in a third country agreed by both parties. Usually for Chinese companies, they would prefer choosing China as the place of arbitration because they are more familiar with the law and the regulations governing the dispute resolution, the form of arbitration. The parties can either submit the dispute to an ad hoc or provisional arbitration organization or to an institutional arbitration body, which was set up as a permanent organization for dispute settlement. 仲裁的形式可以分为临时仲裁和机构仲裁两类。In case of ad hoc arbitration, parties have the opportunities to determine their own arbitration procedures by choosing arbitration rules, location of the arbitration, languages of the arbitration, the law applied to the arbitration, and the arbitrators. The arbitration process is tailored to the specific circumstances of the dispute. A successful ad hoc arbitration often depends on the skill and experience of the attorneys and arbitrators involved. Parties may also choose to take advantage of the established mechanisms and procedures offered by one of the many institutional arbitration bodies. These institutions have formal procedures and rules designed to assist parties. Such procedures and terms and conditions are tried and tested. This means that the fundamental steps of the process, including costs, are managed and controlled by the institution. In practice, the choice of ad hoc arbitration or institutional arbitration depends on the parties, the contractual circumstances, and the nature of the dispute. Majority of the companies prefer institutional arbitration. Some major institutional arbitration bodies are CIETAC, 中国国际经济贸易仲裁委员会 CCPIT, 中国国际贸易促进委员会 London Court of International Arbitration, LCIA in London, 伦敦国际仲裁庭 International Chamber of Commerce, ICC in Paris, 国际商会 American Arbitration Association, AAA, 美国仲裁协会 3. The rules of arbitration. After the place of arbitration has been decided, usually rules of the place of arbitration apply. The rules of other countries may apply if agreed by both parties and the arbitration commission. 4. Arbitral award 仲裁裁决 An arbitral award is a determination on the merits by arbitration tribunal in arbitration and is analogous to a judgment in a court of law. The award is final and binding. That means the parties cannot appeal arbitration awards in the courts. Arbitration award is an award of damages against a party. The arbitration tribunals have a range of remedies that can form a part of the award, such as order a party to pay a sum of money to the harmed party. This is conventional damages. 责令一方向另一方支付一定数额的金钱，这是常规的赔偿损失。To make a declaration as to any matter to be determined in the proceedings. 就仲裁过程中要确定的事宜作出声明。To order a party to do or refrain from doing something. 责令一方做某事或不做某事。To order specific performance of a contract. 责令特定的合同执行方式。To order the rectification, setting aside, or cancellation of a deed or other document. 责令纠正、搁置或取消器具或其他文件。Finally, fees of arbitration are usually borne by the losing party or agreed otherwise by both parties.